one thing in contemporary terms. But what we wanted to know is what the meaning of Article 7 meant when it was written, when it became part of the Constitution in 1792. So what I asked Mr. Lambert from Legislative Services, the research division, was to begin to investigate, to determine what the answer to that was. The principal understanding that I've heard, and I'm not saying this is the entire story at all. One of the arguments was from the outset that Part 2.7 only applied to lawyers. And so we want to make sure that if that's the case, we want to see, we want to examine historical documentation, find out whether or not that was in fact true. So it took quite a while initially to try to figure out where to go with this, what to look at. And so the logical thing that seemed to me initially was to first look at William Plummer's writings, who was a principal proponent for the creation of Part 2, Article 7. And we learned from that in the 1780s, what we had in the House were, this is primarily lawyers doing this, but it was not confined to lawyers, we learned, were individuals who, all members of the House or members of the General Court. In fact, we still use that terminology. And so what we found was that Representative Plummer was complaining a great deal about lawyers taking cases and promoting petitions before the General Court, which was going to hear the legal cases that he was bringing to the House. And Plummer found that very offensive, and first he tried to change the practice by House rules. And the proposal was voted down with all the lawyers voting against the rule change. So later on, in 1792, 7 years after the convention, 7 years after the adoption of the Constitution, it was required to have a Constitutional Convention to look at all the problems with the Constitution. And this was, by the way, was part of the presentation that Professor Stu Wallace gave last week, for those of you who weren't there. And he explained the nature of this conflict. So, in 1792, to Concon, Plummer kept at it, and he promoted Part 2, Article 7 as an amendment to the Constitution at that time. And it was passed by the Concon, and it was passed by the voters. Now, the question still remained, because this is my view now. I know maybe other members of the committee will have a slightly different take on this. But, it appeared at the time, at least from the initial documentation, the practice must have been more widespread than just lawyers. Lawyers had defeated trying to limit their behavior under rules, and in the Concon, I know it was, there was a motion in the course of that to prohibit lawyers from even serving the legislature, and that was soundly defeated. So, when the article is written, it makes no note whatsoever of attorneys. It speaks of advocates, etc., as you can see from the language of Part 2, Article 7. So, here we are with documentation that certainly suggests that the amendment was intended to be generic in nature, not specifically confined to lawyers. But we had no actual written documentation that would have confirmed that. And so once we had the historical material together, by the way, I didn't mention that I have a list of the historical research which has been done for anybody's perusal, so you can also reference this on your own. So we want to know, well, I'm going to have to track a little bit. One of the things we did do in the course of this, just parenthetically, is to gather a whole raft of examples of the types of petitions that were entered before and after this amendment was adopted. We looked at, there's a catalog that was done by Mr. Devins, is it? Eagers. Anyway, a catalog of all of the early petitions were cataloged. So we could go to the archives and pull this list of petitions off. For example, that were filed between 1787 in 1795, so we can book in the adoption of Part 2, Article 7. We can see whether there's any change in the types of petitions that occurred before the adoption of this article versus after. And in my view, having looked at that, you can't really find any real difference. There's no change, particularly in the types of petitions that are being proposed. Some seem to obviously have some legal issues involved with them, and others are simple as arguing whether or not someone should be appointed JP or not at a given time. I mean, it's all over the map, and it's interesting to look at. So there's no particular evidence whatsoever in the petitions themselves as to a change in practice. In any event, we go through all of that, we collect all this material, we get to 1792, the passage of this constitutional amendment. And so then the next question is, well, what happens after that? And Mr. Lambert continued to do some research, and he found that in 1793, the House adopted a House rule in response to the passage of Part 2, Article 7. And this material is available, as I said, for anybody who wants it, public information. But for the benefit of those who haven't seen it, I'd like to read what that rule said. And I've been moving my papers around so much. Yeah, here we go. June 11, 1793, so the committee to prepare a rule to be observed by this House, explanatory of a clause in the Constitution, respecting members taking fees, dean of council, etc., reported the following as fully explanatory of said clause, to wit, that no member of this House shall either directly or indirectly take any fee or reward for bringing forward or supporting any petition or motion before the legislature or either branch of the same or committee thereof, and by his receiving the same or accepting any promise or compensation therefore, he shall forfeit his seat in the House. Now that is the language that the House adopted in 1793, immediately following the adoption of Part 2 of Article 7. And I think, as you can see, it's absolutely generic. It applies not only to lawyers, it applies to anybody. And I guess that's understandable, because if you were a lawyer serving in the House at that time, I imagine you would object to your being prohibited from taking fees to promote a petition if the guy next door, who wasn't a lawyer, could take fees to advance the petition. So that rule, and then so the rule was adopted, and as I said, as they say themselves here, it's fully explanatory of said clause. So then the next question is, how long might that rule have been in place? Because clearly it's not in our House rules now. I just happened by accident to see a set of House rules from 1845. It was not in those House rules. So the question is, how long was it in the House rules? And since it obviously came out of House rules, why might that be? So Mr. Lambert did some further research, and I think he finds it comes out in what, let's see, It was in House rules for 6 years, from 1793 to 1799. And when we look at the journals of that period, we find no particular debate as to why it came out of House rules. And I think the supposition may have been that perhaps people began to think of it as being redundant. Because why would you have a House rule that's already in the Constitution? So, since that time, it has not been in House rules, but the meaning of it seems fairly clear from the historical documents. It was there long enough for everyone to understand what the context was and to establish an understanding. Now, if you were to just stop right there, and you were to say, what are we going to do in this particular case before us? You might take you might take a step and say, well, we ought to initiate hearings on the status of Representative Brunelle and Representative Brunelle's status in the House vis-a-vis Part 2, Article 7. I've had some conversations with others, and I'm taking some time here, but I want to get through this, and then we can open up this committee and further discussion. But what disturbs me a little bit about being that precipitous is, as I have raised the subject myself on Part 2, Article 7 in the last 15 years, I read it one way, And when I talk to attorneys, they tell me it's something else, right? They tell me it only applies to attorneys. And I covered that earlier. I know now from historical record it does not only apply to attorneys, but the contemporary understanding has been that it did. So I think before we go too much farther with this thing, we probably ought to spend a little bit of time to look at contemporary past practices in the context of our understanding today, before we launch into some more formal way of handling this. So that's where I am right at the moment. I'm not personally, although initially I thought we'd kind of have to move to that point. I think in the interest of not only Representative Brunelle, but I think in the interest of any representative in the House, I think we probably want to take a look at exactly that question as to how House members and Senate members may have considered Part 2, Article 7. And so I would be interested in taking this another step and actually asking our House, not only Mr. Lambert, our own committee researcher, to begin to develop a picture of that understanding in contemporary terms. And I think once you have the historic record, you have the contemporary understanding, then I think you can make some kind of judgment, rational judgment as to what step to take next. So that's where I am at, and I'm going to open this to anybody.
As you know, I'm a new representative, and I've been listening and learning, and I appreciate the process with which you've gone through this. I know that this is very sensitive, and I appreciate how you've been trying to get all the information. But I have a question, and it's as a new representative. What is Representative Brunelle accused of? I'm not clear on that. I just know I went to my first session in the House and heard this surprise. Can you help me out with
Okay,
that,
good.
please?
I think that's worth picking up on. Representative Brunelle is the paid executive director of the Democratic Party.
That's his job.
That's his job. His job in the House is as floor leader, which is to advance the Democrat Party's objective on the floor of the House. So he's being paid by the party as the executive director, and his job in the House is to advance the agenda. So to individuals looking at that, and I don't want to speak for Representative Riazzo, but for others looking at that, you say, well, you have money over here, it comes to the individual in the House, and then the individual in the House acts in concert with the direction from the party, and that is the nexus. So it's a money nexus. For example, I mean, I've heard stories like that, and one of the reasons I mentioned, we might want to look at contemporary practice. I've heard stories about powerful people in the House being employed by corporations and to advance their interests. I've heard stories. I've never seen any hard evidence to that effect, but I've heard stories. And obviously, Republicans were in charge for a long time. So I'm talking about members of my own party, perhaps. This is pure speculation. So, but if you're being paid, if you have an entity out here who's paying any member of this room, who's a representative of the House, to act on their behalf, to move their agenda, move their specific agenda, bills, motions, whatever it takes to kill or advance stuff, I think my reading of Part 2, Article 7, my reading of certainly the understanding in 1793, is that would cause you to forfeit your seat. Now, last week we had a presentation on legislative ethics and on lobbying, and the interesting distinction between legislative ethics we normally have and what this issue involves is that legislative ethics is not necessarily dealing with constitutional matters. It's dealing with circumstances where, let's say I'm an architect. I am an architect. Let's say I am. And I file bills that are going to provide some remuneration to me personally. That is unethical. And in fact, I can't file bills that would benefit a blood relative, a member of my family, et cetera, et cetera. There can't be a money connection between me and what I'm doing in the House, for my own interest. And if you read the ethics rules, that's mostly what it's about. That's where we have disclosure, and we not some of that stuff makes any sense the way it works actually in practical matter, but theoretically, if, well, I mean, what I do is I declare, right? You fill out this form, you say, I am involved in real estate, I have this, I have that, I mean, I own apartments, I X, Y, Z. That's on file, so if anybody wants to take a look at my behavior in the house, they can go over there and they can say, well, Murphy's obviously acting in his own interest, and we ought to file some kind of complaint. As I think Senator Russman said last week, he said, if you ever have any question about whether or not something is ethical or not, you probably ought to file a disclosure form just to make sure. But that has to do mostly with personal self-interest. Although, you can certainly have a circumstance that you're being remunerated by somebody else to behave in the house. I mean, it's conceivable, or if there's a quid pro quo between someone else in the house and yourself, you get into trouble. The difference between our ethics rules and this particular provision is ethics doesn't say that if you violate the ethics rules, you forfeit your seat. That's a draconian, it's kind of like, it's pretty final. And the reason why this is not in ethics so far, I would see it, is because, I forget whether it's part 2, 4, or 5, but anyway, the House, I think I got the wrong article there. The House is, maybe it's 22. The House is, it's 22, right, it's 22. I was thinking about the powers of the House, I missed that. But anyway, I think part 2, article 22, the House is responsible for its own members. It has exclusive authority over whether or not they sit or go. So that's really beyond, you can't, I don't think you can hand this off to third parties outside of the House. Not this, because we don't have a provision for it. And there may be some of you on the committee may disagree with it. That's my point of view. So I felt that given that it is the responsibility of the House to do this, and the House is in charge of this question by the Speaker, that we need to kind of proceed with it. So it begins with this business with Brunelle being the executive director of the Democrat Party taking direction. Now, I don't know whether, I don't know what kind of order, what kind of contract he has personally. We haven't even got to that. We've been trying to find out what the bloody part of Article 7 meant. So coming back to the beginning, right now, I think I have a personal understanding of what the 2-7 means from the historical record. But I also know that there's been a considerable difference in the papers that's been voiced in the papers by some prominent individuals. I understand Chuck Douglas has said it on applied to lawyers, for example. So there are prominent individuals in the state who have taken an opposite view. I don't know where to get that information. I don't know where they look at this or not. So I think if we in the legislature have been operating under misapprehension, then I think we ought to know it before we launch into hearings that just address, for example, now. So I hope that's not overly worded.
No, thank you, I appreciate that. I think if I understand it, and I'll just ask this and then please, I'm sorry, I don't mean to monopolize.
No.
I'm a retired professor, and I've been in education for 48 years. Now, if I were still teaching at Queen State College, and I were to submit a bill in relationship to education, is that what you're talking about? Would then I have to give up my seat?
No. If you were being paid by Keith,
Right.
you can't have the bill.
Right.
Yes.
Yeah. Okay.
Right.
Okay, thank you.
If you don't have a financial interest in the bill, no. And generally, there is a gray area where some of us are more scrupulous about how we respond. But there's a gray area that if you're in a profession and it affects everybody broadly, then you're generally can be excused from that. Although I think I would agree with Senator Russman, that if you're in a profession, you're entering bills that have to do with the profession, you probably ought to be signing this. You probably ought to be reviewing it to the House on the floor for Rule 16. That's my own opinion.
I appreciate it. So
But he said, when in doubt, file. Yes, for Bill Kids.
Well, I'm in the same boat that Representative Johnson's in, with one minor difference. I am employed by Kent State College. Does that mean that I can be subjected to the same kind of thing that Representative Brunelle is being subjected to?
Not.
Because they pay me for teaching a 2-credit course.
Not unless they pay you. This way I would read it.
Okay,
Yes,
well,
I
I'm
read my
confused.
My read would be that Keene State said, Representative Chase, we want to enter you, we're going to pay you, enter a bill that will benefit us this, in this way, this way, this way.
So just signing a contract with somebody and being an educator is not enough to trigger.
I don't think so. I don't think so. You could conceivably, I think, now we're into the ethics, we're not into Part 27. And I'm speaking mostly in the context, I understood Representative Senator Russman. I don't think just being employed prohibits you from doing that, although if you have a money connection, you probably should declare it and reveal that you may have a conflict. You don't know whether you have a conflict, but if someone comes to you and says, Representative Chase, I want to pay you, I want to pay you.
I'd say no.
Do X, wow, that's smart. Do X, Y, Z. Then I think you fall within Part 27 without question. Because you're no longer representing constituents, what you're doing is you're acting on behalf of an individual, a third party. That's my take. Yes, Representative.
Thank you. I would like to know, what is the process today? What is it we're doing today? And who is going to be allowed to see? How are we going to proceed today?
This is still a work session. It's for the committee to work to now decide what the next step is. We have a historic record before us, and we understand it. And I think it's up to us today to decide whether we're going to go to a hearing or whether we're going to take a look at this next. Whether A, there's a reason to go to a hearing, or whether we think we ought to get a contemporary understanding of what the Part 2 Article 7 means, as I said earlier. Now, maybe we want to have a hearing to just have to just receive testimony on that subject alone. What does the contemporary mean in Part 2, 7? How has it been presented in the press, etc.? Because if that's the way the House and Senate understand it, then clearly there may be a disconnect between what the historical record says it is and what we believe it is, and that may have some bearing on what the committee decides to do with respect to representation. So I think, what do you want to do today? I would like to get the sense of the committee of what the next step ought to be. Where you'd like to go. Yes.
But this is not an executive session.
No, it's not.
So we will not be taking any kind of vote, is that correct?
Not in the final disposition, that's right. But for example, I think if we wanted to have a hearing on that particular subject, we could do that. We could have a motion to have a hearing on that, just on that particular subject, for example, if you want. Because this is not the ultimate, because we're not doing anything to dispense with this question in its final form. And I would think we'd have an executive session when we come to that point. But I don't think we're doing it, personally, I don't think we're doing it. Others, yes, Reverend Bill.
Thank you. Maybe somebody in the room can answer this question. Was Representative Brunelle employed by the Democratic Party before he ran for the House?
I don't know. Would someone want, I don't want to open this up to testimony. If someone in the audience can answer the question.
I bet I had lots, yes.
Okay, yes.
Thank you.
Others, yes, Reverend.
I'm concerned about the splitting the hairs difference between working for someone and being paid by that person to do something. Are you saying that you don't believe Representative Brunelle works for the Democratic Party in so much as you believe that he's the tool of the Democratic Party to advance an agenda?
I think the tool is the wrong word. I'm just saying, because I think that I want to get back to the fundamental here, which is, if you work for an entity and you're not being required to perform a task in the House for that entity, let's say it's public service. Public service is not telling you, Representative Brown, file this bill, if you're not financial bottom line interest. That's if you're not engaged by them specifically to do that, then I don't think then I would think you would probably have to go on the Part 2. But on the other hand, let's say you work for PSNH, and there are bills that come up that have a PSNH connection, you're not being directed by it. So it's on the table, and you are employed. I think you have an obligation to disclose that connection. And decide for yourself whether you should vote on the subject, because that is affecting your employer, it could potentially affect your job status. It's the difference between being directed, as this language says. Let me read it one more time. It says that no member of this House shall either directly or indirectly take any fee or reward for bringing forward or supporting any petition or motion before the legislature. As an active, you would be an active agent with respect to the bill, motion, whatever it is. So if you're not an active agent, you still have a conflict of interest. But I don't think you would fall under this provision of the Constitution. That's the way I would. Yes, follow. Look, I'm giving you my opinion. Everybody else.
But my question is, how do you make a determination as to when a person is working for someone and when a person is being paid to do something with that person? I mean, in the case of Keene State College, it would be pretty obvious, but say, for example, I work for the Sierra Club. I don't. But the type of person who would work for the Sierra Club would probably be interested in a lot of environmental issues.
Sure.
With the fact that they introduce a bill about an environmental issue, how do you determine whether they're just a person concerned about the environment or a person acting on behalf of somebody else? How does that
I
determine?
believe they had a contract with the Sierra Club in a particular bill. It would fall under Part 2, Article 7.
So are you saying that you need some sort of contract to prove that that person is being paid by?
Well, you don't need a written contract, but you can have a form, there are other forms of contract, right? I'm just saying, well, wait a minute, there's remuneration involved here, right? If they're being remunerated, directly or indirectly, to file a piece of legislation, or, as it says here, supporting any petition or motion before the legislation. Really, if they're actively engaged, serving that end for someone in exchange for some remuneration, then I think, I would think there would be a violation of Part 2, Article 7. But if you remember the Sierra Club, we all belong to a variety of organizations, right? I think obviously if you're generally interested in environmental issues, you're going to vote on environmental issues, but you are being paid by an entity. And I think you get back to the disclosure issue. If there's money involved, you sort of have to disclose. I just give you my personal thing. I am a director of the New Hampshire Wildlife Federation. Quite frankly, I have not, and I've now not gone to, I used to recommend what bills ought to be filed in this House. I don't attend the legislative hearings anymore, and I haven't even been to a director's meeting since this subject came up. Because I worry that I have not wanted to put myself in a position where I could be appeared to representing one of the positions on the floor. And I've generally taken Rule 16 many times in the past when I had a conflict, but I'm struggling with this myself, and I may be overdisturbed. Yeah, continue. I have a question over here.
Yes, I was interested if we could possibly discuss for a minute, I guess, the difference in terms of possible ethics violations, in terms of, say, introducing and advancing legislation versus voting on legislation. Because obviously, I guess, if you're employed by any organization, as you were saying, we all could maybe fall into some gray area there, but we do have the option of filing a conflict of interest and not voting on that. Whereas, obviously, he's been voting, but he has also filed legislation in his capacity too. So, are we looking at one or the other? Are we looking at both? Do we have documentation on where he has filed about, possible conflict?
We have not got to that point where we've actually looked at what is filed or not filed. The subject's come up. The subject came up because that was a presumption. We have not got to that point yet because I don't know what we're dealing with here with respect to Part 2 7. I think that question needs to be asked at some point downstream. But right now, we ought to know what the meaning of this. We've been spoken to what the meaning of this is historically, and I think it comes back to what I said earlier. We ought to have an understanding of what it means to temper. Because I think it may have some mitigating. Some of us may think it may have a mitigating effect on this. Yes.
Mr. Chairman, in reference to Representative Brown's example of this being employed by the Sierra Club, I think the way I see it, more specifically than the fact that you're employed, would be what role you're employed in. And I think really getting to the basis of this matter, what is an executive director of a political party, and what is he supposed to do in that capacity? It's one thing if you're, the errand boy for the Sierra Club, or if you're a real estate broker like I am, that's one thing. But if you are employed as an executive director of a political party, what are your responsibilities? And that's a question I asked last time, because in using Mr. Brunelle's attorney's
What I'd like to try to do is not get into,
but as far as that goes, I think that's really the question here. What does he do for a living, and how does that impact his actions on the floor of the House? That's what I keep, I'm getting this, as I said, I'm a real estate broker. If there's a real estate issue, I have some knowledge of real estate, just like, everybody has an area of expertise. Representative Chase might have something to offer as a professor of real estate in the education field that I work. And we are a volunteer legislature. Every one of us has a job, most of us have a job outside of it. I think it's really the specifics of your job, I think is really what this is coming down to. How I kind of understand it. I didn't know if you had an answer for that or a comment for that.
I think I said that. Other members? Yes, Reverend Duarte.
I think I'm first year too. So when we first came on board, I was asked to do this. And that's the first place I went on this, Mr. Chairman. And there are a few things in there that, concern me. And the main one is when we start talking about conflict of interest procedure, which was sitting here, and I'd like to mention that. And under section 6, part 3, it says prohibited activities. It states, a legislative employee or officer shall not accept any employment or serve in any position in addition to legislative employment which would impair the employee or officer's independence of judgment. And I went down a little bit farther. This happened to come back to me when we started getting involved in this. And under section 15, B:3, it says prohibition in gifts. If you need a definition of gifts, it does make checks and cash in the previous paragraph. But it specifically says that it shall be unlawful to knowingly give any gift as defined in this chapter, directly or indirectly, to an elected official, public employee, constitutional official, or legislative employee. And then under section 3, no elected official, public employee, constitutional official, or legislative shall knowingly accept, directly or indirectly, any gift as defined in this chapter. There's so much material, on this issue. All I'm concerned about is that we handle this properly and fairly, but it would be, I think it should be in our gun sights here, it should be in our future to see if we can clarify what we can do, what we can't do in the future to keep this from coming back up again. But there's a lot of information I would need before I could, make a fair decision on this. But I would certainly like to bring that up and explain that. That seemed to catch my eye, Chairman. Thank you.
Yes.
Following up on what Representative Ball said, to me, if I'm to make any determination about the applicability of, former precedent or law, whatnot, I would need to know what exactly his role entails, what is his job. So I would imagine there must be some sort of contract or job description that he had to sign at the time that he took on the role of executive director of the Democratic Party that describes what his job entails, and I think that would be very helpful to, well, it would be to me, I don't know about to the rest of you, to then be able to go forward and find out what exactly we're looking at.
let's see, I'll start with Chase, I'll come back this way.
I tend to be a down-to-earth, practical, hands-on kind of person. And the question that occurs to me is, has Representative Brunelle, is there any claim that he has taken any money for filing a bill?
No. Well, let's put it this way, well, actually, that's not entirely correct. The presumption is, I think that what the question was raised was, he has filed, I think as I recall, he has filed some bills which were interpreted as political, primarily for political reasons. I don't know whether it's not, look, I'm not judging, I'm not prejudging of it, but the assumption was that he filed it as a member of the House, but also as executive director. He filed legislation to serve interests. I don't know, we haven't got to the hearing part yet, so I can't answer that question. That's what I read.
Isn't that what everybody here does?
Not if you're paid. I don't,
I mean,
I don't follow.
don't we all, I haven't filed a bill, please. But I've seen lots of people file bills that appear to me to be political. And I don't understand what we're doing here. I mean, if he's done what Mr. Plummer said in 1792 about filing bills because we're going to get paid for it, has he done that? Is it, just because he believes in certain principles and files bills based on those principles, does that mean that he's advancing Democratic agenda? And don't the Republicans do the same thing?
If you're, again, we come back to the subject which began, which is if you're paid to do it. It's one
So
thing.
we don't, I'm sorry.
No, I'm just saying, I just reviewed my, now,
Right.
I've given you my reading of this, and everybody else in the room may have their reading. What Plummer's saying is if you're paid to do it for a third party, would be a violation of Part 270. Yes, I have some other questions. Let's see. Representative Paul, first,
It seems to me as I'm listening here that there's a little bit of a leap in here. Of course, we don't know his job description, but the question is, did anybody really ask him or pay him to do any of these bills that constituents can ask you, but that's different than someone from the Democratic Party office or something.
I think the questions have to do with what he does, what he is doing. Well, I think it comes to Reverend Garcia's question. We don't know.
Yeah.
And we would have, eventually, before this committee could come to conclusions for how to handle this, you would have to ask those questions in some, through a hearing process or a manual, so you could gather information, you could request it, I suppose. But we had not got to that point because, as I said earlier, there's been some, because of the subject matter, Part 270, as I said at the beginning, and if you have been following this article has never been adjudicated before the court. That's the only history on it we've been able to find is really what Mr. Lambert has been able to dredge up, so. I think we're getting ahead of ourselves. I think that question has to be asked, but now's not the time to ask it.
I just need a little clarification. Representative Brunelle is a paid executive director of the Democratic Party.
That's what I understand.
Which party? County, state, federal, state?
I didn't have that.
All up, yes?
I just, for historical context, in the 1790s, it was Peter Burling's of the world, running the show. However, Peter and I have had our disagreements over the years, but I do think that in 2011, the diversity of things that we all do, I'm a realtor as well as Representative I could easily file some bills through, if the Association of Realtors called me and said, geez, would you put in a bill for us? Sure. Do I get paid directly by them? No. I make a living selling real estate, but do I get paid by them? I get conflicted, I think, with Representative Brunelle, the fact that he was employed prior to running for the House. I don't think I know Representative Brunelle if I fell over. But I do think that he did get elected by his constituents. And I think that, to me, has a fairly large bearing.
I think, given the gravity of the situation we find ourselves in, considering the historical context that we've been able to glean from Part 2, Article 7, I think we really need to take a look at the contemporary meaning of all this, and I would just maybe move that the committee direct legislative research to give us some input as to who may have run afoul of this recently. Has there been any investigations of anybody else regarding to, getting paid by a third party or being involved with a third party and being the sponsor or voting on certain legislation? I think we really need to have that research done before we can do anything else on this.
So your motion?
Yes, I move that we have the legislative research investigate the contemporary meaning of this for us and find us, members in the last decade or two or so who have potentially run afoul of Part 2, Article 7, or any other third-party payments.
Second.
I'll second that.
What would be the, yes, I'm just now open for discussion.
Are we talking about bribes and bribery, but can't say the words and on the
No, I
table
don't
and
think
under
so.
the table?
I don't think so. No, this is a formal, well, if you can prove it, but this is, I think, you would be saying a formal relationship. Yeah.
Yeah.
I would think he's saying a formal, above the board relationship. I don't know how you get to your question, but. Yes, Roseland Martin.
I think the more information, that we can gather for this committee, would probably lead us to a better decision overall as far as fairness and maybe set some precedents in the future, to make sure that this question doesn't arise again. But I think that there's a lot of questions that I have as well as I'm sure the rest of the committee will really get over what bills and so on. That's been brought up. But I think it's a good idea for this committee to receive more information and input on what we're dealing with here. This is a very serious thing. And for us to be fair-minded and do the very best, Franklin was my favorite, and Franklin always said, if it's the right thing to do, I want to do it. It's the wrong thing to do, I want to avoid it. And I think this helps us come to that conclusion. Thank you.
Yes, sir. Thank you, Mr. Chairman. I agree on the point that Representative Kidder made. As a fellow Manchester representative, and Representative Brunelle is as well, I know he ran an election just like I did, and he represents more than 3,000 citizens. And what we're talking about here is an issue that could potentially jeopardize the results of an election. And that's a serious thing, it's a very serious thing. Those people elected him, they know who he is, they know what he does for a living, they had plenty of opportunity to research him, and they selected him as their representative. So this is a dreadfully serious thing that we're talking about, and I think the more information we've got, the better. And for no other reason than Representative Brunelle deserves every possibility for us to be as well informed as possible. And I think that we can't leave any stone unturned as far as educating ourselves on this matter. And I would completely agree with the motion.
Is there any other discussion? President Pelletier?
Yeah, I may have missed this since I wasn't here earlier when some of this was going
opening day of session, at the end of session, Representative Giazza raised a question on the floor of the House as to Representative Brunelle's qualifications to serve based upon Part 2, Article 7, with the understanding that as executive director of the New Hampshire Democrat Party, he was on the floor advancing, being paid to advance their agenda. And
Did he ask the speaker this, or?
yes, and the speaker assigned the task to this committee to try to sort this out. And going painfully slow for some people, I'm sure, but I think it's probably the right thing to take it. That's how it got here. The speaker charged this committee with,
So that's just one accusation, is that it?
that's right, it was raised on the subject of his qualifications. So, our job is to try to look at this, and then come to the House with a full House with a report. And to hold hearings, whatever we have to do, to basically satisfy that request of the speaker. And we're kind of moving through it, and it's turned out to be, in some ways, more complex than perhaps we originally seen. But it's taken some time, and I think it's Representative Gitter raised it. We're taking some time to do this, right? Yes.
I just thought I'd point out that the matter being referred to the attention of the chair was directed to us by a vote of the entire body, not just a request of the speaker.
That's a good point. It was ruled out by the House. Appreciate it. Yeah, so let's see, Representative Johnson and then.
Thank you kindly. Did Senator Brunelle, did anybody?
Representative Brunelle.
I beg your pardon, excuse me.
You're lucky for him, right?
Yeah, really, yeah. Did anybody meet with him before this was brought to the floor?
I
Or
don't,
was this a surprise?
I don't know, yeah, I don't absolutely answer, I think it was a surprise.
Okay.
I can't say. Yes, Representative Wall.
I have been around here for a while, and it seems to me, and to tell you the truth, I cannot remember the names of the people at this point, but it seems to me that we have actually had serving in this House before people who were employed by the Democratic Party and people who were employed by the Republican Party. And I don't remember ever this kind of a situation where these people were subjected to this kind of activity. I guess I would really like for people to think about that, and I think my memory's probably right. I couldn't tell you their names though. Maybe their faces as they walked in, but not their names.
This is a response, I was thinking, maybe you'll extend your motion to the direction of Representative Walter's been in the House, because you have the longest experience of anybody on the committee.
Mr. Chair, if I could.
I'm just being interested.
If I could, Representative Wallner, that's exactly where I was going with that motion. I want to be apprised of people who may have been employed by either party in the past, and whatever resulted from that employment, if it was looked into, if there was any action taken, if they were questioned and, later found out that there wasn't any conflict of interest. I think that's the kind of information that I'm trying to get in that kind of motion, so I'm going in your direction there. That's what I'm trying to go with this.
Representative Garcia.
Yeah, well, so I guess my initial comment started off with Representative Kidder and now come around to Representative Wallner. But to me, I think all information is important, so I would like to see, if any such complaints have been filed, what the decisions have been and whatnot. But if none have, and as Representative Wallner said, there have been people employed in the past and all of that to me is a bit irrelevant, because the point is that people could have been ignorant of our ethics laws, and all of that we've been discussing. So, and going on to, that he was elected by a constituency who may or may not have known, I don't really think that's relevant to the case. This is a complaint where another representative from Manchester, said, this is a problem, as I see it, it's in violation of this, there's a presumption at least. And so we need to, considering all of that, we need to consider that at this point, this has been a complaint. So this may be the still think it's very important that we know what his job description is and the terms of, contracts that we have.
All right, to follow up on that a little bit too, I feel that we should go ahead and check out the information as Representative Comer brought about contemporary practices and how that relates. If something was brought before the board before, we need to look at that. But I also think, like Representative Garcia said, in helping Representative Brunelle along this process and to kind of speed things along, if we come to the point after we meet and look at our contemporary practices and still finding the same issues, there's some bits more of information that I would like to see as well. And maybe if I can reiterate some of my issues to bring about my one question I'm wondering I'd like to see some information on. Just to bring it back, in reading Article 7, it states that only those taking fees for any cause brought before the council. And I heard a lot today about the issues of somebody, in brokers or electricians per se. But I don't think that an electrician would be in direct violation if you brought up a case for an electrician, something that would help their fellow electricians, because his pay is not a direct fee from groups advocating a change in the water pipe or in the electricians. So I bring that up again because as a director of a political group being paid by special interest groups, I want to see maybe which special interest groups put their money towards the Democratic Party, because I think then we could look at cases specifically. If there's no cases where these things he's voted on since the session has begun, or the bills that he's sponsored that correlate with any of the groups that have, given money towards the Democratic Party, then that's some kind of information I'd like to see. So if it goes beyond the contemporary practice section, we find that we have to go further, have that information soon, so we don't have to stretch this on and help Representative Brunelle get on with things.
Thank you, Mr. Chairman. Before I say what I'm going to say, I want to be very clear that I'm not accusing anyone of anything. However, some people have suggested looking at Representative Brunelle's contracts, some people have suggested looking at donations to the Democratic Party. I think we as a legislature should be extremely wary of using our legislative authority to delve deeply into the inner workings of a political organization. I think that's something that, I think that you're honestly looking for information to help you make a decision. I'm by no means saying that, but I think that when we step back as a legislature and say, we are going to use our authority as a government to go poking into a political party and finding out whatever we can about them, I think that's just a very dangerous step to be going down. So while I understand what you're saying, we have to exercise extreme caution, because that is not a slope that I want to have anyone here going down.
Let's see, President Duarte and then Representative.
I think some of the concerns I have is that we keep looking at things that have happened in the past, and I'm not really sure that's a good idea, because if we were doing things wrong back then, should we try to stop the practice and do it right from here on out? That at least we show when we're here and accomplish something for the future, so that it doesn't happen again. I keep coming back to that. Thank you.
Let's see, Representative Chase.
I kind of wanted to piggyback, thank you, Mr. Chairman, on what Representative Duarte said a few moments ago about precedent. What we do in this committee is going to have tremendous implications down the road. And we need to be really, really careful. Representative Ball and Representative talked about the elected representative, that he is an elected representative of his constituents. We don't want to set, in my opinion, the precedent of having to disenfranchise a group of our citizens. That's more than just a little slippery slope. That's a downhill ski jump. Seriously, that is not a place we want to go. And I feel my responsibilities very seriously. And it's not unusual for me to wake up at 3 o'clock in the morning thinking about this. I want to be sure that we don't set precedents that are gonna sandbag the other people who come forward from the commitment of their own hearts to do the best they can as public servants, because that's what we all are, public servants. Where they're going to sandbag good people who are afraid to become public servants.
Let's see. Yeah, Reverend.
Mere employment constitute a violation. Representative Brunelle is employed by the state Democratic Party. Does that in itself make it a violation of House ethics under Chapter 2, Article 2? And a follow-up? When people aspire to elected office, there are a lot of people knocking on their doors, calling them on the phone, and offering them financial support. And if a candidate accepts a remuneration to assist in his election, and then is successful in getting elected, is that considered payment for services when he then goes forward to advance his political party? I mean, I was elected by a whole host of conservative Republicans across Hillsborough County's 4th district, and I would hate to think that somebody would challenge my seat in the House because I accepted money from the state Republican Party. And Mr. Brunelle is accepting a paycheck from the state Democratic Party. This money.
How deep can you dig that hole?
That's a good, maybe we're gonna find, we'll see where it goes, right? Reverend Brown.
Thank you, Mr. Chairman. I think a fundamental problem here is that we can try to find out information as much as we can, but we are not going to be able to find out what is going on in Representative Brunelle's head. And I think that a lot of this comes down to when you're talking about people who work for political organizations, people who work for charitable organizations, you get paychecks from them. Do they represent those companies because they're being paid, or do they work for those companies because they represent what they already believe? You know, certainly, I think if someone were to show me a piece of paper that said Mike Brunelle's salary was X on one day, and he introduced the bill, and it was X plus $1,000 on the next day, that would be a clear case of something that you're talking about here. But we're talking about somebody working for a party that presumably represents what he believes. I mean, it's just kind of hard to untangle the web of what does he believe, what is he doing because he's being told, you know, it's intense when you start talking about things like this. Is, you know, everybody's got to make a living doing something. Why don't I make a living doing something that I actually enjoy? And does that put me in a position of now I'm being paid to advocate their position?
I appreciate that. Okay, now, let's see, I'd like to, Reverend Duarte and Representative Garcia, perhaps we can get the motion or something.
I think my question is, my father was a commercial fisherman, and I think if I fished with him and got paid for that, and I were to submit a bill, and I have to be a legislator, I think my common sense would tell me that I couldn't do that. I mean, if I'm enhancing a situation, okay, that I'm part of, I would feel uncomfortable with that. I think when I first ran for this office, I didn't have one of these. It kind of gave me a little bit of guidance. I think it would have been nice on the front end if somebody told me a little bit about what I could do, what I couldn't do. I mean, I've been a selectman for 4 years, I can do that, but this is totally new. And I think the more information that I receive up front, gives me a little clearer picture of what I can do, what I can't do down the road, that might again lead us to something maybe we get along down the road, how we can eliminate this problem. But that would be my feeling on that. I think I would be very hesitant, and I think my questions would be on similar situations to Mr. Brunelle. And he may you know, worked for that particular party, but what was actually on the bills and any of the legislation that was submitted, that would get that down the road. But that would tell me a little bit more, exactly, you know, what position I would take on it. And I think that would clarify it for me. Thank you.
Garcia,
Thank
and
you.
perhaps we
So, again, following up on Representative Brown said, again, really, I think it's really important to know what the requirements of this job is, because naturally, if you have a, political philosophy or a belief system that would align you to be sympathetic or opponent of the Democratic Party, you could also work for the Democratic Party by being the treasurer for the state party. However, that's very different from being, perhaps, the executive director, where you're perhaps not following orders, you're perhaps setting the agenda and making the directives yourself, and then coming through the legislature, creating them, inspiring other people to follow you, and therefore actively promoting it. I don't know. So that's why I'd really like to know what this job is.
One last thing.
Having had some experience, and thank you, Mr. Chairman, Representative Garcia, working on nonprofit organizations as an executive in a position where I worked with an executive director, is the executive director does what the board of directors tell him to do. He is employed as an employee to carry out policies. He doesn't make policy.
That's fine. I've also worked with
So that's, you seem to want to know an answer, so I gave you the best I had.
Well, Representative Brown pretty much put it where it is a very difficult charge every night. And it's complicated, and it is difficult. If you don't mind, perhaps we could, something kind of, move the question, we can kind of get through this next one. Thank you. Would, Representative Conover sort of prepare to try to restate his motion? He's good. So the objective here is, for the committee would like to do is to charge legislative research, our own committee researcher, perhaps that's Representative, I want to call him Representative, Rich Lambert, would help us get to the questions which Representative Cromford has made for, and perhaps we have a work schedule. I scheduled a meeting for next Thursday because we're kind of out of step with a calendar. I reserved the time for 2 o'clock next Thursday. What I'd like to do after next Thursday is to get our meetings back into Tuesday. So I'm just saying, whatever we can do in the next week, fine. If we can't get it within that time frame, maybe we'll just have a very brief meeting. And then our researchers will finally tell us when they've got enough material that would make it worthwhile for us to come together. And yes,
I know you've made a motion. I would like to know if we can be a little more specific about what are these questions we're asking? Can we all know, I wanted to know what the questions are that we're asking Mr. Lambert to research.
why don't you think you get that,
Yes.
hang on a second.
I'm just gonna, basically, what I have written down is basically directing the legislative research office to research the issue that we are having at hand in a contemporary way. Also taking into consideration cases that were similar to this one that we are right now discussing regarding Representative Brunelle. It's just directing them to do the research.
I think Representative Cromwell would like to clarify.
Just to clarify that a little bit for clarification, what I was trying to get at there was Representative Wallner brought it up also, is that she has recollection of people who have in the past in the legislature have worked for either party. What I'd like to do is have them research, who had been a legislator and worked for one of the political parties at the same time, what was done with it, if anything, and if that was an accepted practice. That's part of the charge that I was looking to get at.
I would say that my understanding would go another step further, and I would be interested in, because we have heard stories about other members of the House serving the interest of, as I said, corporations, perhaps. And if that's the case, I think we have to I think it should be a broad charge, say for the last 20 years, if he can do it. Pick that as a time frame. I think that's what the council was talking about. And so we have some examples of, we'll find out if there are examples, I don't know if we have or not. That's essential. One last thing I'll let you know.
I'm sorry to interrupt the process, but you know, I'm having trouble even thinking that I would like to vote for this motion, even though I understand the intent. Because in the meantime, in my heart, a man is being crucified, and if he's to be used as the person who's going to prove whatever this point is, that doesn't feel right to me. I would be happy to go ahead and research all this if Mr. Brunelle's name is taken off this. Because if we're starting from today forward, that does not fit for me if this man was elected and he's now sitting in office. I'd like to move ahead and find these answers out, but I don't like to do it with his name included. Thank you.
Now we're voting, would the clerk please call the roll?
Office, and I think we should only look at things that have come up against people who have held office. If we start going back in time and starting to look at everybody, I just think that's counterproductive unless something was brought up, a charge against that person in the past.
I would say, I think the motion is not that specific. I would deny unless it's
Right.
Representative Walton.
Well, I don't know if this, you would allow this, but I would like to know if Mr. Lambert feels, at this point that he has enough clarity to go forward with the kind of research he's asking to do, and I'm sure we would allow him.
I would say not at this point. Meeting with the chairman, that we could achieve a clarity. I'm willing to do whatever can be done that's appropriate for me to do.
Why don't we do this? Why don't I appoint a subcommittee?
Always.
No, what I was doing because I want to make sure that, I got tripped up, right, so that you have an opportunity to get that together, so. Let me do that, I'm gonna do that right now. I'm gonna appoint Representative Bamford, Representative Ball, and Representative Wallner, and Representative Pitt. And I think you can discuss this with Representative Lambert, and you can, I'm open. I say representative, I want to get you elected. No, just to clarify that one.
Right, but
You think it'll take you this time?
no, I just have an issue here with what the process we had a vote which disposed of a motion that I made which directs research to research what the motion directed to research, so it's 16 to 2, it's done. That's what the motion is, we voted on it.
I withdraw my thought. I'll tell you what though, why don't we meet afterwards? With Mr. Lambert, take a few minutes and we can talk about this and make sure we're all clear in terms of everything.
May I just have one comment? Well, I think it's really important that all of us know what we're instructing him to research, and when I wanted to be sure he knew. I mean, I think we all voted, I agree with Representative Cumber, we all did vote, but I think it's really important that the person who has to do the work really understands the charge, and that's why I wanted to be sure to ask him for it again, because we probably should have done that before.
Let's try it this way. You want to repeat your intent? Just one last time.
Okay.
See if we can get this.
What the motion was directing you to do, Mr. Lambert, was to look into, as Representative Wallner said, situations where there were representatives employed by either political party while serving in the legislature. Number two, whether that became a problem or an issue of ethics as to whether they were receiving third-party fees to advocate for certain legislation motions or what have you.
Part 2 concerns me to the extent that complaints before the ethics committee are confidential, unless they reach a certain point. Of the 55 complaints before the committee, I would say 46 of them are confidential.
identify which members of the House may have been working for youth organizations, for example. And, I guess all we can do is develop that inventory of individuals. And as I said, as we were having this discussion, I hope that making a motion would agree to this, is that to the extent to which, there may have been reports on individuals serving corporations, or those kinds of entities, while serving the House, where this kind of conflict might have been raised, it would be of interest, I think, to the committee. Is that more or less covered?
Yeah, that's pretty on
Is
target.
that clear enough for you, President Wall?
I'm not doing the research.
Well, I mean, does that work, does that seem? I'm just saying, I mean, that's consistent with our understanding, is what I'm saying. Fine, okay? Okay. Well, there'd be nothing, is there anything else you care to come forward with, anything else? I'd like to.
I just would like to say, Representative Mansfield, I want to thank you for the process. I know that this is very hard to facilitate, I appreciate what you're doing. Yeah, I still walk away confused, but I appreciate you modeling leadership in this role. Thank you.
Now, this is there, but for the grace of God, go out kind of issue, so I'm gonna close this.